Good afternoon, and welcome to the American Constitution Society's annual Supreme Court preview. I'm Zanelle October, Executive Vice President of ACS, the nation's leading progressive legal network with nearly 200 student and lawyer chapters in almost every state and law school in the country. Through our diverse, rapidly growing nationwide network of progressive lawyers, law students, judges, scholars, advocates, and many others, ACS's mission is to support and advocate for laws and legal systems that strengthen our democratic legitimacy, uphold the rule of law, and realize the promise of equality for all. If you aren't already, I'd encourage you to become a member of ACS and to donate. Our work is more important now than ever, and we need your support. Go to acslaw.org, where you can join, donate, and find more information about events like this one. Some quick housekeeping notes before we begin. This afternoon's discussion is being recorded, and the recording will be available on ACS's website after today's program concludes. For those interested in CLE credit, information is available in the chat. Finally, there will be time during today's discussion for audience questions. To submit a question, please use the Q&A box at the bottom of the Zoom screen. Do not use the chat box to ask your questions, as we will not be monitoring it, and your question will not be put in the queue. If you are a member of the press, please include the name of your outlet at the beginning of your questions. For the past 3 years, the conservative-dominated court has demonstrated that it is all too willing to upend long-standing precedent and inject increasing uncertainty into constitutional law to achieve the goals of the conservative legal movement. This has placed the legitimacy of our nation's highest court at risk. It has caused lasting damage to the court's reputation with the public, as reflected in historically low levels of public approval. And it has made it difficult for litigants, lawyers, legal scholars, law students, and really all of us to predict what the law might look like as the conservative bloc seeks to work its will. We have seen the consequences of this court's decisions. It has imperiled a person's right to control their own body and access reproductive health care, including abortions. It has allowed the First Amendment to be used as a license to discriminate against LGBTQ plus folks and to inject religion into our schools and civic life. It has created a legal regime that protects the most powerful, including a sweeping grant of immunity for presidents and the weakening of the federal agencies that are meant to protect our health, our environment, the rights of workers, and the most vulnerable among us. It is a court that is jeopardizing the health of our democracy. This term is not yet stacked with the type of blockbuster cases we have come to dread, but in the shadow of a hotly contested national election, this term could be shaping up to be quite consequential. So what does the Supreme Court have in store for us in the coming term? To help lead our panelists in discussing this very question is our moderator for today's preview, Hassan Ali Kanu, staff writer for the American Prospect. Hassan is an award-winning reporter who covers the courts, access to justice, politics, labor, and more. In his decade-long career in journalism, Hassan has also served as a columnist for Reuters and as legal editor for Bloomberg BNA. He is a graduate of Morehouse College and Duke Law School. So now it's my pleasure to hand things over to Hassan to kick off today's conversation. Hassan?
Thank you so much, Sanel. Hi, folks. Thank you all for joining us today. Thanks in advance to our wonderful superstar panel here. Thanks, of course, to ACS. I've paid attention to ACS's work for quite some time now. And certainly since I switched over to journalism, I've watched these previews as well as the reviews that ACS does at the end of the year, looking at the term that just passed, and I've always found them very helpful. And I imagine our audience will find this today's conversation just as informative. So thanks again to ACS, and thank you guys for your great work in general. As I said, if you do watch those past Supreme Court previews, you'll hear for the past several terms, folks say that they are expecting a historic term, or that the term that just passed was a history-making term. And this one doesn't look to be any different. It's certainly fair to say that we're in a history-making period, certainly in the life of the Supreme Court. So very much looking forward to hearing these great folks talk about that today. Just a couple housekeeping items. Please feel free to ask questions as they occur to you. We, in fact, encourage your questions. Just be sure to put those not in the chat, but using the Q&A button at the bottom of the Zoom screen there. And we'll try to get to those questions, as many of those questions as we can. The other housekeeping item is just a CLE credit. There will be a second code that I will give about halfway through the program. The first code is pumpkin. So again, the first code is pumpkin. It looks like the codes are fall themed, I believe. I don't think Starbucks is sponsoring this or anything. But yeah, so I'll get to the second one of those later. And certainly, as I said, the court is in a historic period, not just because of the cases it's taking, but also because of sort of the news, the controversy surrounding the court, and the justices. And so if we have some time, we will certainly try to get to those issues and question of court reform and those matters at the end of our conversation. So with that being said, I'm going to go ahead and jump into it. I'll try to keep these bios very short. As I said, we have a superstar panel of folks here. You can certainly Google any one of these folks and get a fuller bio. But we have 5 folks with us talking. We'll be talking about gun rights case, LGBTQ rights case, and more. The court can certainly take up more cases through its emergency docket. And so we'll talk about petitions and all that at the end as well. So just brief introductions before we get into the first case we'll talk about. We have with us Gautam Hans. He's a professor at Cornell Law School. He's also the founding director of the law school's Civil Rights and Civil Liberties Clinic. We have with us as well Patty Ferguson Bonney. Patty is a professor at Arizona State University. She is the director of the Indian Legal Clinic there and also head of the coordinator with the Native Vote Election Protection Project there in Arizona. We also have Katie Iyer from Rutgers Law, who will be talking with us about the LGBTQ civil rights case that I just mentioned. Professor Iyer's work was instrumental, and she's been credited with originating the theory that underlies the Supreme Court's expansion of anti-bias protections to LGBTQ folks. We also have Professor Daniel Epps from Washington University, who will be talking with us about Glossop v. Oklahoma. Professor Epps is perhaps best known, that's a joke, as the co-host of the Divided Arguments podcast, along with Professor William Bode as well. And we also have Professor Andrew Willinger, from who is both a student and professor at my alma mater, Duke Law School, and also director of the Duke Center for Firearms Law. So with that being said, because we are both Dukies, Andrew, I'll go ahead and start with you. I'm joking. It's more so that your case is first on the calendar. This case will be heard on Tuesday next week. And this is a gun rights case called Garland v. Vanderstock. So with that being said, with no further ado, Andrew, please tell us about this case. And yeah, over to you.
Great. Thanks so much, Hassan. Really appreciate the introduction and really happy to be here with everyone today. So as Hassan mentioned, I'm going to be talking about Garland versus Vanderstock. This is actually not a Second Amendment case, which is where I spend most of my time, but it is an administrative law case that involves firearms. And this case will be argued next Tuesday, October 8th. So one of the first big cases to be argued this term. As in terms of a roadmap for what I'm going to try to do in my remarks, I'll talk a little bit about the main issue in the case and some of the factual background, try to run through the arguments, or at least the main arguments that have surfaced in the briefing so far, discuss my prediction very briefly for how the court might rule. And then if I have time, I will try to touch on a couple of Second Amendment petitions or issues that are sort of percolating up to the court, and that might be ones to watch for the coming year plus. So let me jump into Garland versus Vanderstock. So what is the issue in this case? The issue is really this sort of high level, almost existential question of what is a firearm? And relatedly, whether the agency that is primarily tasked with regulating firearms, the Bureau of Alcohol, Tobacco, and Firearms, or ATF, exceeded its statutory authority by passing a rule in 2022 that broadly categorized gun assembly kits and partially complete frames and receivers. Sort of, you might think of those as the building blocks of a firearm. And ATF's rule categorized both of those items as firearms under the Gun Control Act of 1968, a major piece of federal gun control legislation. Now, what are gun assembly kits? You might commonly see these referred to by the term ghost guns. That's how I've mostly seen them reported in the media. And basically, these are kits that contain the parts and tools that are needed for somebody to construct a firearm on their own at home, often accompanied by instructions or maybe links to a video about how to go about doing that assembly process. The kits retail for a few $100s. That can vary depending on the type of firearm. And again, they generally would contain everything that a person needs to self-manufacture or self-assemble a gun, starting with an unfinished frame or receiver. Now, why is this a regulatory problem or a concern? So the Gun Control Act of 1968 applies only to firearms. That is a defined term in the statute. It's defined to include the frame or receiver of any such weapon. And the idea of the GCA is to channel the sale of firearms through federally licensed dealers who are required to conduct background checks at the point of sale to screen for things like minimum age, possible disqualifications from possessing a gun, like a felony conviction, mental illness, and so on. So the idea is to sort of put this on the front end. So federally licensed dealers have to run prospective purchasers through a background check system to make sure that they meet the qualifications to actually own a firearm. Now, a gun that is self-assembled through one of these kits, generally speaking, is going to be unserialized, untraceable, and as long as the kit and sort of the building blocks from which you can construct a gun through the kit are not within the scope of the defined term firearm, manufacturers and sellers of the kits don't have to comply with any of the background check requirements or other point of sale requirements in the GCA. So you can see why this would be a major potential regulatory concern for the ATF. Ghost guns or self-assembled firearms are increasingly recovered by law enforcement. They have become much more common over the past decade or so, especially the last few years. And that includes ghost guns that are recovered from crime scenes. That number has jumped dramatically. And as a result of this, ATF in 2022 promulgated the rule that is at the center of this lawsuit. And ATF expanded the statutory definition of firearm in the GCA to include both these gun assembly kits and the unfinished frames and receivers, sometimes called 80% frames and receivers, that the kits actually turn into firearms. So again, those are sort of the building blocks, and you would use the kit to complete the process. So there are two claims in the case. The plaintiffs, the respondents at the Supreme Court, challenged two portions of the final ATF rule. They challenged the expansion of the firearm definition to include gun assembly kits, and they challenged the expansion of the frame or receiver definition to include partially finished frames and receivers in an earlier stage than the definition previously covered. Now, the briefing in the case so far, I think as expected, has been heavily textual, heavily focused on the language of the authorizing statute, the surrounding context of the GCA, the fact that the GCA includes in its definition any weapon which may be readily converted to expel a projectile, and how broad that language can be construed by ATF. The respondents in the case emphasize that, in their view, kits cannot logically, as a linguistic matter, be their products. And as one of the Fifth Circuit judges below put it, in the Fifth Circuit struck down the rule. That judge said that ATF, under this view, could potentially regulate as a firearm anything beyond primordial ooze. So this dispute about how far ATF can regulate given this expanded definition. There's also discussion about the statutory purpose of the GCA, whether the proliferation of these gun assembly kits allows people to evade the objectives of the legislation. There's sort of a high-level debate as well about who the proper actor is to respond to this type of regulatory concern. Is it Congress by passing legislation to actually amend the definition, or is it the ATF? You also see debate in the briefing sort of back and forth about how long it actually takes, how complicated it is to assemble firearms in this manner. As you can imagine, the government argues that this is a very easy process. It doesn't take very long. It doesn't take much skill. The respondents take a contrary view. And there are also some ancillary arguments related to, first, the rule of lenity. So the fact that this is a criminal statute, and that generally criminal statutes are construed against imposing criminal liability if there is any ambiguity. And also a constitutional avoidance argument made by the respondents. So I mentioned this is not a Second Amendment case. There's no Second Amendment claim, but there are arguments that sort of relate to or revolve around the right to keep and bear arms, and specifically the right to make firearms, whether maybe that's part of the protection of the Second Amendment. And I think if some of these arguments or issues sound familiar, it's because the Supreme Court actually decided a relatively similar case this past June called Cargill, Garland v. Cargill, which involved ATF's regulation of bump stocks, devices that increase the rate of fire of a semi-automatic rifle. This was under a different piece of federal legislation, but again, similar claims, similar result below, striking down ATF's rule as in excess of its statutory authority. And the Supreme Court sided with the challengers in that case and struck the ATF rule by a 6-3 vote along partisan lines. So how do I think the court is likely to rule in Vanderstock? It's always difficult to make these types of predictions, especially before we have the benefit of seeing what questions the justices ask at oral argument. But we do actually have some clues here from the emergency or shadow docket about which way certain justices are leaning. So in August of last year, the government sought emergency relief at the Supreme Court after the Fifth Circuit had issued an initial preliminary injunction vacating these two provisions of the rule. The government asked the Supreme Court to stay that decision pending the Fifth Circuit hearing the claims on their merits. And the Supreme Court granted that motion with 4 noted dissents. So Justice Thomas, Justice Alito, Justice Gorsuch, and Justice Kavanaugh were the 4 dissenting justices. So it granted the motion by a 5-4 margin. And of course, you also needed 4 justices to vote to grant cert. So I think the way, reading a little bit into this prior shadow docket decision and the fact that the court subsequently granted cert after the Fifth Circuit invalidated the rule on the merits after a full briefing and hearing, I think means that there's probably no overlap. So it would be a little bit odd for any of the 4 justices who had voted against the stay motion to vote to grant cert, because presumably they think the Fifth Circuit got it right. And that leads me to think that this case is probably a real toss-up and that we will probably see a very narrow 5-4 decision with Justice Barrett and Chief Justice Roberts being sort of the key swing votes. And it wouldn't surprise me to see the court actually uphold the ATF rule in this case, or at least uphold it in part. And that's based on just what I think is the strength of this intuitive argument that we frequently, as a linguistic matter, deem things to be within an overarching category, even when they are not in the final finished form of that category. So one example from the briefing here is a piece of furniture, a table, for example, that you might buy at IKEA. Now you buy that table, it's not fully assembled. You can't just take it home and put it in your house. You have to actually build it, but we still refer to it as a table. So I think the justices might be inclined to take a similar view of the question of what constitutes a firearm. Now, if I can just touch very briefly, I know I'm probably up on time here, but I'll just briefly hit on a couple of these other Second Amendment petitions that are sort of filtering up to the Supreme Court and that may be ones to watch over the next few weeks and months. The first of these is challenges to state bans on assault weapons and large capacity magazines. The Supreme Court has actually never addressed the question of what weapons and accessories are protected by the Second Amendment. And so there's a case out of the Fourth Circuit called Snope v. Brown, where there is a petition in the sort of the search stage briefing right now. And I think that's a prime candidate if the court does want to address this issue for a future cert grant. Another issue that is percolating at the lower courts is age restrictions. So state laws that restrict 18 to 20-year-olds from buying, carrying, or possessing certain types of firearms. There are a couple petitions that have either been filed or I think will be filed in the next few weeks where federal appellate courts struck down these types of age restrictions. And these cases implicate interesting questions related to the Supreme Court's 2022 decision in Bruin and the historically focused test that the court has mandated in this area. Specifically what historical time period judges are supposed to look at for analogous regulation. Finally, a brief word on the federal ban on convicted felons possessing firearms, which I think is a major issue to watch and one that the court will probably need to take up in the coming terms. We have already seen a circuit split develop after Bruin and the Supreme Court's decision in Rahimi this past June about whether it is constitutional to prohibit convicted felons from possessing guns across the board, no matter what the underlying felony conviction at issue is. Some circuits have taken that view, or whether in certain cases, nonviolent felons who have a long subsequent history of law-abiding conduct can actually bring a successful as-applied challenge to the federal law banning gun possession and recover their gun rights. So that's one to keep an eye on. And again, I think one that the court will need to step in and resolve at some point soon. So I'll leave it there, but happy to talk more about Vanderstock or any of those cases in the Q&A.
Great. Thank you, Andrew. We will go next to Patty Ferguson-Bonney. Patty's going to tell us about a voting rights case out of Arizona called RNC v. that's Republican National Committee v. Mi Familia Vota. So please go ahead, Patty.
Well, thanks so much. And I'm so happy to be here. And I'm going to talk about the Mi Familia Vota case. And I think a lot of people have questions about what does Mi Familia Vota mean with regards to Purcell, the Purcell decision. And so I want to talk a little bit about how we got here and the facts, but I want to go back to Purcell and how that decision was issued, because I think it'll make a little more sense. In 2004, Arizona passed a documentary proof of citizenship and a voter ID law. At that time, we were covered by Section 5 of the Voting Rights Act. In 2005, DOJ pre-cleared the law, and then there was a facial challenge to the implementation of that law. And the challenges resulted in two Supreme Court decisions. One was Purcell, and one was the Intertribal Council of Arizona decision, both which are relevant to the Mi Familia Vota case. So in Purcell, most people see this case as meaning that courts should not change election rules during the period of time just prior to an election, because it could confuse voters and create problems for officials administering the elections. And so when we look at what happened in Purcell, I think the facts there are very different than most of the cases that are going to the Supreme Court in election cases. But there in that case, the district court had a preliminary injunction hearing, and they denied the plaintiff's motion for preliminary injunction. But before the court issued a findings of fact or conclusions of law, the parties appealed to the Ninth Circuit. And a two-person motions panel, two judges and a motion panel, blocked the law until there would be an appeal on the merits. And basically, that decision, it was like a 4-line decision. And there was no oral argument, and they granted the injunction, denied reconsideration, and gave really no reason. After they issued that decision, that motions panel decision, then the district court issued its findings of fact and conclusions of law. It was like a week afterwards. And the district court found possibility of success on the merits, but they couldn't say that they had a strong likelihood, and the balance of harms weighed in favor of denying the injunction. So then about 8 days later, the Supreme Court issued a decision as part of their emergency docket. This is just, this was on October 20th. The election was on November 7th. And basically, I just think it's really important to reflect back on what the court actually said. It said that the Court of Appeals has to give deference to the discretion of the district court, and they found no indication that it did so. And so the court found that that was an error. And by failing to provide any factual findings or any reasoning of its own, the Court of Appeals left the court in the position of evaluating the Court of Appeals' fair order in light of the district court's ultimate findings. There has been no explanation given by the Court of Appeals showing the ruling and findings of the district court to be incorrect. In view of the impending election, the necessity for clear guidance to the state of Arizona, and our conclusion regarding the Court of Appeals issuance of the order, we vacate the order of the Court of Appeals. And in addition, they found that the facts were hotly contested. And since the election was just a few weeks away and there wasn't time to resolve the factual disputes, then the action was to let the election proceed without an injunction, so that the voter ID rules would be in effect. So, the thing that the court looked at was the short amount of time between the order and the election, the need for guidance, and the lack of explanation in the Ninth Circuit's decision. And there, the recorder requested relief because she said it would cause confusion. So this case has been used a lot, basically to say the courts cannot interfere right before the election. And there's a disagreement about what that means. And there have been some cases that the Supreme Court has issued decisions and it has been months. In this case, it was literally 2 weeks. Okay, there was also a later decision resulting from Prop 200 dealing with documentary proof of citizenship. The voter registration law required documentary proof of citizenship to register to vote in state and federal elections. And the Supreme Court basically said that was preempted by the National Voter Registration Act. And so basically what the state of Arizona did post this case is that they created a dual system for registration, creating Arizona voters who are full ballot voters and Arizona voters who are federal only voters. So you could register to vote with the federal form and be a federal only voter, or register to vote with the state form and be a full ballot voter. There was litigation with regards to that. In 2018, there was a consent decree that said if someone submitted a state form or a federal form, this is what the agreement was, if the recorders could find that you have actually provided documentary proof of citizenship by researching databases, including the voter vehicles database, then you would be a full ballot voter. So that leads us to where we are today. So the status quo in Arizona is that you could use either form, the state form or the federal form. But if you didn't provide documentary proof of citizenship, you'd be a federal only voter. If you provided documentary proof of citizenship, or if it could be found for you, you would be a full ballot voter. Well, in 2022, the legislature passed a law, and basically it amended the law to say that to use the state form, you have to provide documentary proof of citizenship. And if you fail to provide that, then your ballot will be rejected. And if a county recorder enrolls you as a full ballot voter without providing that documentary proof of citizenship, then they are liable for a Class 6 felony. Also, if you register to vote with a federal form, they could check to see if you are actually a citizen. And if you are a citizen, you could be promoted to a full ballot voter. But if you are only a federal voter, you can only vote for U.S. Senate and Congress. You cannot vote for the President of the United States, and you cannot vote by mail. So there was some other things that were part of this litigation, but there were a number of parties that filed challenges to this litigation. So there were challenges to this saying that it conflicted with the National Voter Registration Act by prohibiting federal-only voters or registrants from voting by mail and for president, and that it violated also the LULAC decree, the National Voter Registration Act, and the Equal Protection Clause, because you're treating people differently. So there were hearings on this. There was summary judgment issued for the plaintiffs in September 2023. So as soon as lawsuits were filed, this new law was stayed, so it was never in effect. And then in September 2023, we get summary judgment in favor of the plaintiffs. So the judge enjoined the law with regards to rejecting these applications for lack of documentary proof of citizenship and having recorders liable for Class 6 felony. They basically said this violates the National Voter Registration Act. We also have this consent decree, and the state law conflicts. And so that decision was issued, and this was stayed. And then in March, there was a further order basically saying that Arizona cannot reject these state forms, and they must register applicants as federal-only voters. So there was no change in the law. So we have the status quo. We're doing the same thing. And then in July 18th, there was a motions panel, and they mostly denied the request for a stay, but they granted the request for a stay with respect to this LULAC consent decree, which basically was how you treat federal only and the state forms. And that lasted for about 2 weeks. There was a merits panel that granted reconsideration and vacated this partial stay. So at this time, we're about July 18th. We have our primary election July 30th. There aren't very many people registering to vote at this time. And so this reinstated the status quo. So there's a little bit of confusion because these decisions are coming out. Well, interveners filed an emergency stay with the U.S. Supreme Court, and they asked for a stay as to all 3 of these provisions: the presidential voting restriction, the restriction on mail-in voting, and the requirement to reject state form applicants that lack documentary proof of citizenship. So on August 22nd, the Supreme Court granted the intervener's motion for a stay with regards to this LULAC consent decree, basically saying that the counties now must reject a state form that lacks documentary proof of citizenship, but granting the stay with regards to the other 2 issues. So I think the important thing in this is that this is actually changing the status quo. So the court was changing what was in place and what had been agreed to dealing with documentary proof of citizenship in 2018. There is a conflict in the law, basically this settlement agreement and a new law that was put in place. And the change actually has caused confusion on the ground in the state of Arizona because this decision was issued 46 days before the voter registration deadline. Unlike Purcell, there was a very long decision issued by the lower court judge and also by the merits panel, which evaluated and looked at these issues. So a lot of people are looking at this to think about, well, what does this mean with regards to Purcell? So it's, I don't know, right? I don't know, because when you look at Purcell and what people say it stands for, not being able to make changes so close to the election and then actually making the changes and the confusion that it will cause, that this has actually caused quite a bit of confusion. And it's the people on the ground who are actually registering voters who are confused as to, what actions they should be taking. So I think it's, there was no reasoning given by the Supreme Court because this was a shadow docket decision. And so there was just nothing really to go by, but what Purcell was mentioned in the briefings, and it was mentioned in the briefings in the Ninth Circuit as to why they were going to maintain the stay. So I just wanted to point those things out, and I know that we're going to run out of time, but I just want to mention two more things with regards to voting rights cases that are percolating. One has to do with whether or not you have a private right of action under Section 2 of the Voting Rights Act. That issue has come up in the Eighth Circuit that has found that there is no private right of action, and it has been percolating in other areas. There's also a case out of Montana recently where petition for cert has been filed with regards to it results from a ballot collection issue and same-day voter registration under the Montana Constitution. And so there is a challenge, a petition to cert that's been filed in the U.S. Supreme Court, basically also asserting the independent legislature theory that came up in Moore versus Harper. So with that, I'll just pause and I'll wait for questions later. Thank you.
Thank you very much, Patty. Very, very important case there. I'm sure other folks as well as I am excited to ask you more, even though you just quite clearly said I don't know, but to ask you more about the Purcell principle and how we might move forward with that. We'll go next to Professor Daniel Epps, who's going to tell us about a criminal law case called Glossip. I definitely have some questions about this one too. There seems to be some interesting complexity maybe in this case. So please take it away, Dan.
Yeah, thanks so much. And I think that complexity really is the watchword for this case, Glossip versus Oklahoma. Just want to say at the outset, to avoid any confusion, there was a previous Supreme Court case called Glossip. That case is called Glossip versus Gross, and it did involve the same capital defendant. But that case is pretty different because there Glossip was actually just one of a number of plaintiffs in a suit by a bunch of death row inmates challenging Oklahoma's lethal injection protocol. And the court ultimately upheld the lethal injection protocol. And so this case is not about methods of execution. This is about the substance of Glossip's case. And so some background on the case. So Glossip was charged with the capital murder of a man named Barry Von Treese. That murder occurred in 1997. Everybody acknowledges that Glossip did not personally commit this killing and that it was committed by somebody named Sneed. And this is going to matter because we're going to come back to Sneed quite a bit. And Sneed and Glossip both worked at the hotel that the victim Von Treese owned. And the state's theory was that Glossip paid Sneed to kill Von Treese, and that Glossip did so because he was about to be fired. But the evidence of that was somewhat weak. And the key to the case, the key piece of evidence in the case that really kind of made conviction possible was testimony by Sneed. And so that was kind of the essence of the case. Glossop is tried and convicted in 1998. That conviction gets overturned on grounds not relevant here. He's retried and convicted in 2004. So 20 years ago, this case has really been bouncing around procedurally for quite some time. He engages in a long battle to get discovery from the state of potentially exculpatory material, which the state is constitutionally required to disclose to the defendant in a criminal case under certain circumstances, which we'll talk more about in a minute. The state finally complies somewhat in 2002. It turns over 7 boxes of discovery material that include a bunch of things in them that had never been disclosed, and some pieces of that Glossop and his counsel believed to be exculpatory. But then months later, the state decides, well, we're going to turn over another box, box 8. And what is in that box is really what this case is about. I'm going to say more in a minute about exactly what's in there when I dig into the merits. But the short version is there was material in that box that may show that the prosecutor in the case, Connie Smotherman, knew that Sneed, the key witness in the case, lied on the stand when he testified that he had been prescribed lithium, but that he had never seen a psychiatrist. And why is this relevant? Well, the argument would be that this was potentially quite valuable impeachment evidence that could have been used to bolster the defense's case that Sneed was lying and that he didn't, that the claim that he just remembered all these details couldn't possibly be true. There's some other pieces of evidence that Glossop is pointing to coming out of that box, but really the essence of the case is about that piece of evidence that I just talked about. And I'll get into a little bit more specifics about that in a second. Now, going on in the background, there's been a lot of attention to this case, and to, a lot of people have a lot of reservations about this case. And both the Oklahoma legislature and the state attorney general's office commissioned independent investigations, both of which independently concluded that there were really serious problems with this case, and in part pointing to government misconduct relating to evidence, preservation of evidence, disclosure of evidence, and so forth. So upon the disclosure of Box 8, Glossop files for relief under the Oklahoma Post-Conviction Procedure Act. And that act it provides a limitation on a defendant's ability to file a subsequent petition for post-conviction relief that says that such a claim is barred unless the factual basis for the claim was unavailable through the exercise of reasonable diligence, and that but for the alleged errors, no reasonable fact finder would have found the applicant guilty of the underlying offense or would have rendered the penalty of death. The key claims in this petition for relief are that the evidence that the state didn't disclose violate 2 related doctrines. And the first is that under a case that I'm told on good authority is pronounced NAPU, it violates due process for a prosecutor to knowingly permit a witness to testify falsely. And the related doctrine, Brady, which holds that due process requires the prosecution to disclose exculpatory evidence and impeachment evidence, that is, disclose those to the defendant when that evidence would create a reasonable probability of a different outcome. Okay, so 2 related but independent constitutional bases that would, if successful, would require vacating the conviction. Now, here's where it starts to get complicated. It's already a little complicated. It's going to get more complicated. The state attorney general, which had previously, for years been defending this conviction, and actually is still has defended the conviction with respect to an earlier petition that was filed on the basis of the first 7 boxes, now decides on the basis of this latest petition that it agrees that this conviction is tainted, says this was a violation of NAPU, and purports to waive the procedural restrictions put in place under the Post-Conviction Procedure Act, to just say, courts, you should go ahead, state courts, go ahead and grant relief. This gets to the Oklahoma Court of Criminal Appeals. And that court does something interesting for adding to the complexity in that it declines to defer to that confession of error by the Attorney General. It says, look, Oklahoma AG can say what he wants, but it is our job to apply the law. And under the law, as we understand it, we can't grant relief. I'll say that the court's precise reasoning is not super clear. And there's different ways to read exactly what it was saying. And I'll say more on that in a minute. After that, the Oklahoma Pardon and Parole Board declines to grant clemency. It does so by an evenly divided 2-2 vote after the board's chairman recuses himself because he is actually the prosecutor in question, Connie Smotherman. It's her husband. And as a result of that, because of the way the structure of clemency works in Oklahoma, the governor and the whole executive branch is powerless to grant clemency to Glossop. So basically, just to kind of step back, what's happening here is the Attorney General is saying, look, we don't think this person should be executed. We think that this conviction is invalid. And the Oklahoma judiciary is saying, it doesn't matter what you think. This is a valid death sentence, and basically you need to carry it out. So kind of an unusual posture. Glossop then goes to the Supreme Court, files a petition for cert, and the Attorney General files a response, not opposing cert, but actually saying, yes, the court should grant, and the court should overturn the conviction. Basically continuing the confession of error. And the court does grant the petition. Now, I'd say normally seeing the court grant cert in an intensely fact-bound capital case where the capital defendant is the petitioner, not the respondent, is a very good sign for the capital defendant. There's no particular reason for the court to grant a fact-bound case like that unless it's very concerned about the outcome. There's no particular reason to think that this case could be used as a platform for resolving a larger legal issue. It's not some massive circuit split. It's really about this particular case. And so, at that point, that's a favorable position to be in. We know that, just logically, at least one of the Republican appointed justices must have agreed to vote for cert in this case. So some interest in the court and some reason to think the court might be interested in reversing. Then the court does what it typically does in a case where both parties on either side are urging reversal of the judgment below. It appoints an amicus to argue the case in support of the judgment below. This is a very common thing. It happens a couple of times a term, and the idea is the court is saying, well, we can't just grant relief without some being confident that that's really the right thing to do. If both parties are agreeing, we need somebody else just to give us the best arguments. And so they appoint an amicus, a former clerk to Chief Justice Roberts and Justice Kavanaugh, and a former alum of the United States Solicitor General's office with a lot of Supreme Court experience. And he has filed a brief that I think is, very, very well done. And so now we're at the court. And there's several legal issues, I'd think two kind of pretty big ones and one smaller one. Big issues. First, was this a constitutional violation? Did it violate NAPIU? Did it violate Brady? Second, and I'll talk more about these in detail in a second, does the court have jurisdiction even to answer that question? To the extent that the judgment below rested solely, or the reason that the court denies relief is because of state law, that could constitute what's called an adequate and independent state ground that actually precludes the Supreme Court from having jurisdiction to review any federal law issue. And then the third piece would be, what is the what posture should courts take when the executive branch of a state confesses error? Should that be something that courts are supposed to defer to? I call that the kind of smaller issue. And it's maybe more of a kind of, it's something that the Oklahoma Attorney General tries to make a lot of hay out of. I think it's something that's going to be a little bit less front and center in the case, and the first two are going to matter. Okay, so let me just say a little bit about the legal issues, and then I'll try to say what, some thoughts about what the possibilities are. So legal issues, first, was this a constitutional violation? And it's a very interesting case because, I read the briefs kind of in order, the way one normally would, and I read the petitioner's brief filed by, among others, former Solicitor General Seth Waxman, very well done brief. Brief of the Oklahoma Attorney General, also on the same side of the issue, slightly different view of the legal issues, but same bottom line, which is that petitioner should win. Filed the counsel of record there is former Solicitor General of the United States, Paul Clement, who was a Solicitor General in the Bush administration and also, considered one of the best Supreme Court advocates. Both very compelling briefs. And then you read a couple other briefs. You could read a brief by the court-appointed amicus, which is very well done. And I read, there's a bunch of amicus briefs, but one that I think deserves special attention is there's one filed by former federal district judge Paul Cassell, who is a victims' rights advocate, and he filed a brief on behalf of the Von Treese family, defending the judgment below. And so if you read the first two briefs, you come away with the impression that there is just absolutely decisive evidence, smoking gun evidence in the record that shows that the prosecution lied, knowingly put on false evidence. The brief of the amicus comes in and really tries to put more of the attention on the actual evidence in a way that maybe the first two briefs don't, in the sense that the facts section actually says, here is a picture of the thing that they are making a big deal about. And if you look at the actual thing that wasn't disclosed, it's some notes prepared by some other men. And I would say they're a little cryptic. There are notes from an interview of Snead. And among the key pieces in the notes is it says, on lithium, ? Dr. Trumpet, ? And the parties have sort of said, these notes show that Snead admitted he had been prescribed lithium by a doctor who was the doctor at the jail named Dr. Tromka. And they say this is clearly, this can't be contested at this point. The amicus says this is far from clear what was going on. These are just questions. This doesn't establish this. We don't know, whether this actually, he was prescribed this. We don't have that in the record. The brief, calling attention back to the brief, the Von Treese brief filed by Cassell, advances a theory that what these notes are they actually notes questioning Snead about an interview by defense investigators of him and just trying to get him to say what they had said. So it's a case where you really dig into it. The facts are kind of messy, and the court to resolve the case is going to have to really it's going to have to write a pretty fact-bound opinion that really kind of tries to explain how it sees the facts. Do they establish that the prosecutor actually, was aware that this was false testimony? What do these notes mean? And so forth. There's some other things in the record that could be lied on, but I'd say this is the linchpin. And then there's this other question about the adequate and independent state ground, right? And the court is going to have to look at the judgment below and try to decide what was going on. Okay, is this something that totally rests on state law where we don't have authority to do so? And there are, I think, decent arguments that the court does have jurisdiction. So one, is it an independent of federal law? That matters. It's a little unclear. It's unclear when you read the opinion, how much is it actually just addressing the constitutional questions on the merits, at least part of the time it seems to be, And if that's the case, it's not an independent ruling. It's not independent of federal law. There's also an argument that it's not adequate because the court, thereby refusing to defer to the Oklahoma Attorney General's confession of error and desire that the procedural barriers be waived, was deviating from long settled practice. And then the third legal issue is kind of more of an atmospheric point, which is how much should we care that the state attorney general is coming in and saying grant relief. What's going to happen? Well, I will say that I think this is a case where sometimes the court grants cert, and then when it really digs into the case, it turns out to be a little bit more complicated. I do think this is going to be one of those cases, and I do think this is a case where there is a meaningful chance the court actually sides with the amicus and decides not to grant relief, which would be surprising. But you can sort of imagine a story where the court is persuaded to grant review because you have both parties on the same side and sort of concluding there must be something really wrong here. And then it digs in. Maybe the lower court opinion was not persuasive, but the court decides this is a bit more complicated. My inclination is the court, if it's going to do that, is more likely to rest on the underlying merits of the issue than to rest on the jurisdictional issue, in the sense that it's just, the jurisdictional issue seems quite messy, and it does seem to me that there's a reasonable argument that the lower court ruling was really intertwined with federal law, and also just atmospherically, it does seem kind of unappealing to grant this capital case where there's a lot of people saying this is a lot of injustice here, and then say, oh, okay, well, we just can't do anything for technical jurisdictional reasons. That's sort of more of a realpolitik argument, but that is my intuition and guess. So I'd say right now, this case really strikes me as very much up for grabs, and we are going to learn a lot more from the oral argument. I think this is not going to be, definitely not going to be a unanimous case, and the justices sort of currently who hold the power on the court, Chief Justice Roberts, Justice Kavanaugh, Justice Barrett, they're going to kind of tell the story and how they react at oral argument and what their intuitions are and how much how troubled they are and how they read the facts. So there's other stuff I could talk about in terms of petitions, but I think I've gone on long enough, so I'm going to stop there.
Thank you very much, Dan. Yeah, like you said, lots of a good deal of twists and turns in that case there, and interesting to hear you say you don't think the Attorney General's intervention or position, at least in the case, will matter much to the justices. Yeah, so we will move next to Katie Iyer. Katie's going to talk to us about a case called Scometti, U.S. v. Scometti. This is a case about LGBTQ rights, and obviously, we've made some pretty massive leaps forward over the past several years in terms of the gay marriage decision, the decision extending general anti-bias protections to LGBTQ folks and so on. But it certainly looks like we're in a moment where that might come to a screeching halt or perhaps even start to regress. So we will talk about what's at issue and what's at stake here in Scometti. And actually, just before I pass it on to you, Katie, just a reminder to folks, please do remember to submit your questions again on the Q&A section. And I will share the second CLE code, which is foliage. Foliage as in fall and leaves. So yeah. On to you, Katie.
Thank you, Hassan. I'm very happy to be here. The case I'm going to be talking about here today is United States versus Scometti. I could talk for much longer about Scometti. Fortunately or unfortunately for all of you, we have just about 10 minutes. So I'm really going to focus on 4 primary issues. So first, just a general overview of what's going on in this case. What's the factual backdrop? What are the legal issues? Second, because I think it's actually especially important to this case, a bit about the broader legal landscape that this case is a part of. It's part of a much broader legislative movement that's been going on across the states. Third, what would the Supreme Court say in this case if it was indeed following our established equal protection doctrine? And then finally, because a lot of folks out there are worried that the court may not take that approach, what are the various ways the court could shift its equal protection doctrine if it is motivated to try to avoid a finding in favor of the transgender litigants here. So first, what is this case about? Skrmetti is a challenge to Tennessee's ban on gender-affirming care for transgender minors. There were both the United States had intervened on behalf of the plaintiffs and private party plaintiffs. Here, the court specifically granted just the petition of the United States. So the private parties are represented by the ACLU and they are participating, but the court specifically was focused on the petition filed by the United States. The Tennessee statute, just by way of background, quite explicitly bans gender-affirming care for transgender minors only. So, for example, it is still entirely legal in Tennessee for a cisgender teenager to receive breast augmentation. So it clearly distinguishes based on transgender status. It also classifies based on sex. So there's no way for the doctor to know, is this procedure banned, except to look at the sex assigned at birth of the particular individual. And then finally, also relevant to the equal protection analysis, there is a carve-out in the law that specifically allows any sorts of procedures, including genital surgeries, to be performed on intersex infants who may not have any capacity to consent. So it particularly tailors the law to only focus on the medical services that transgender minors receive. So Skrmetti is significant for a number of reasons, but among them is that this is really the first opportunity for the Supreme Court to address the rights of transgender people under the Equal Protection Clause. So the court has heard a number of cases addressing the rights of transgender folks under other areas of the law, both constitutional and statutory. It's obviously heard a number of cases that most people have heard of with respect to the LGB part of the LGBT community, but this is the first case they're going to take up addressing transgender rights and equal protection. Those are the basics of the Skrmetti case, but as I alluded to, I think this is a circumstance where it's also important to understand a little bit about the broader legal landscape that this is arising out of. So transgender rights, and in particular, the rights of transgender youth, has really become one of the primary targets of the so-called culture wars in state legislatures in recent years. And this bill is a part and parcel of that. For those who don't follow this area, to give you a sense of the scope, so far this year alone, 658 bills have been introduced across 43 states seeking to restrict transgender rights in a wide variety of ways. 45 of those bills have passed in this year alone. So we're talking about a really sort of stunning volume of state level legislation addressing issues from healthcare to athletics to identification to how students can be treated in schools. So really across the whole range of issues for transgender people. And just an enormous volume of legislation targeting this particular small minority community. Why is this broader background potentially relevant? Because, of course, this is what the Supreme Court has told us modern equal protection doctrine is supposed to be built for. So those of you who are lawyers probably remember from your 1L constitutional law class, famous footnote 4 from Caroline Products, which becomes the foundation for the modern system of the tiers of scrutiny. And the idea is that while we sort of leave economic legislation alone, we give it only de minimis scrutiny because we are not suspicious of classifications there, where we have legislation targeting so-called discrete and insular minorities, that the court should really give it a closer look. And in particular, where we are worried that we might have political failures, a group that is being targeted that is unable to defend itself in the regular political system, that's where the courts really should be giving it closer scrutiny to make sure that classification does not devolve into invidious discrimination. So that's one of the major equal protection principles that Skrmetti seems to implicate. It also seems to implicate exactly what the Supreme Court has told us it's rather rigid modern anti-classification framework is supposed to be for. So one of the most critiqued aspects of equal protection law is what I like to think of as the doctrine of no exceptions, right? The idea that when heightened scrutiny applies to a particular type of classification, like race, it is always suspicious. We always apply a higher level of review, even where the government's alleged motives are benign. So this is, of course, the principle that comes out of the affirmative action cases. And the Supreme Court has told us this rule is necessary because heightened scrutiny is what is needed in order to allow us to really know whether or not the government is right, whether this is actually benign, actually justified, or whether instead it is harmful. This principle seems obviously important here, right? We have the government of Tennessee claiming that they are actually protecting a vulnerable group, right? That this is intended to protect children who may come to regret these procedures. But then we have the overwhelming majority of people, both minors and adults, who are subject to this law, claiming that this is causing real harm. Indeed, there's a recent study that came out that showed the passage of these types of limitations on care and other anti-transgender rights measures are causing increased suicide attempts among transgender minors. And in fact, what we've seen is that every court in which that has required the government to actually introduce real evidence, applied something other than de minimis rational basis review, has found, in fact, that these laws banning gender-affirming care for minors can't satisfy that standard. The government can't, in fact, prove their claims that this is beneficial as opposed to harmful to minors. And that includes judges across the ideological spectrum. But of course, the Sixth Circuit in this particular case, in Scrimeti, went out of its way to avoid applying any form of heightened scrutiny, and as a result, applied a very deferential form of rational basis review and found that the law survived, without evidence, survived that review. Although I am a legal optimist and would like to believe that the Supreme Court is going to reject that reasoning, which I think is clearly wrong for reasons I'm going to talk about under equal protection law, lots of folks are, I think, reasonably pessimistic and believe that the Supreme Court too may go out of its way to try to avoid applying heightened scrutiny here. So with the remainder of my time, what I'd really like to talk about are, if the court is determined to do that, right, it really will require them departing in novel ways from established equal protection law if they really want to avoid applying heightened scrutiny to this law. So what are some of the possibilities, and what would those possibilities mean, not just for transgender rights, but for wider equal protection doctrine? And the first possibility I want to just briefly discuss is sort of the most radical, which is that this may be the case in which we see at least a soft turn towards originalism in the context of equal protection doctrine. If you read the Sixth Circuit's opinion in Scrimeti, there's a clear implied invitation to the court to do that. The majority chides the plaintiffs for not arguing that the original fixed meaning of the Equal Protection Clause covers their claims. This is nonsense for anybody who knows equal protection doctrine, in the sense that originalism has not been a part of equal protection doctrine since at least Brown versus Board of Education, but it's obviously an invitation to the court to consider changing that. And of course, the idea that the court might pick up this invitation is not wholly unimaginable. We've seen the court ignore precedent in numerous areas of constitutional law over the last 10 years to shift them in a decidedly originalist direction. And some of the constraints that have traditionally kept the court from adopting originalism in the context of equal protection, which I'm happy to talk more about in the Q&A, I think have really eroded today, mostly due to the malleability of originalist arguments, which makes it seem less like there's bright lines that will keep them from moving in that direction. Obviously, a turn towards originalism in the context of equal protection would have potentially profound implications outside of the context, even outside of the context of LGBTQ rights. Virtually every group that has protections through modern equal protection law did not have similar rights 150 years ago, right? So there are very good reasons to think that, you know, a turn to originalism and equal protection could have quite devastating effects for modern equality law. I should be clear, I don't think this is the most likely thing to happen in Skermeti. I think even if the court decides to find against the transgender litigants, if anything, originalism is likely to be a sort of soft theme, you know, an initial volley that they might build on later. What I think is rather more likely is that the court will find ways to lessen its anti-classification based approach or depart from its anti-classification based approach in the context of sex discrimination specifically. So this is the approach that the Sixth Circuit took. It said, you know, basically, look, all of these rules about that you have to strictly apply heightened scrutiny wherever you have one of these suspect classifications or quasi-suspect classifications, that works for race, but it shouldn't apply in the context of sex. So the idea is we shouldn't subject sex classifications to meaningful equal protection review where they are benign, so that unlike race, where we do parallel levels of scrutiny even for allegedly benign classifications, we don't need to do that for sex, or that where laws like this one burden both sexes equally, that those types of classifications should not receive heightened review. To be clear, even this more limited turn in equal protection doctrine would also have really profound implications. And again, this is obviously true for transgender rights, but it is also true much more farther afield. Many of the traditional sex classifications that we now recognize as invidious and unconstitutional, having to do with the rights of cisgender women, were once defended as benign and as helping rather than harming women. And so too, the equal application argument, which is being proffered in these cases, has a very long and shameful history in equal protection doctrine. It was the argument that underpinned upholding bans on interracial marriage and ultimately upholding the separate but equal regime. So, you know, basic takeaway here is there are real risks to walking back the anti-classification rules that got us to this point, but that there are reasons to believe that if the court doesn't want to apply meaningful scrutiny to this law, which it may not, that is the type of turn it may take. So again, because I am an optimist and a believer in the rule of law, I am hopeful that the court will do the right thing here and say this is a sex classification without even reaching the issue of whether trans folks on their own should get heightened scrutiny. It's clear it should be subject to heightened review. And all they would have to do to respect existing doctrine is say that, send it back to the lower court to assess whether or not that standard is met. So I know I'm just about out of time, but just to give a little bit of backdrop about petitions in this area, there are a ton of cases percolating, particularly in the area of transgender rights in the lower courts. Some of them are pending cert petitions right at this time. One of the cases I'm following is the BPJ case. This was a case out of the Fourth Circuit where they struck down West Virginia's rule, which said essentially at all ages, transgender athletes can't participate in sports in accordance with their gender identity as opposed to their sex assigned at birth. That case, again, was a victory for the plaintiffs below and is pending cert right now. There's also a variety of cases in the lower courts that are being brought by anti-transgender advocates claiming constitutional rights. So for example, there's a cert petition pending called Parents Protecting Our Children versus Eau Claire, which is looking at the issue of whether schools can treat children in accordance with their gender identity, even if their parents object, and even keep that information confidential. I can see that Hassan is unmuted, so I'm guessing that means I'm out of time. I'll turn it back over to you, Hassan, and happy to talk more about these issues in the Q&A.
That was not meant to be a prompt. That would just be rude. But I'm glad you noticed. We will go next to Professor Hans, who's going to tell us about a free speech case that is ostensibly, at least on the surface, about minors' internet access, social media, pornography, and pornography on the internet. All these issues are wrapped up in this case called Free Speech Coalition v. Paxton. So please go ahead, Colin.
Hi, everyone. So this is going to be very fast because I see that we are low on time. So this is a case that arises out of a Texas law, the site of so much of our favorite recent cases in many forms, including in free speech. I'm going to rewind us about 30 years to some of the very first internet law cases. These include Reno versus ACLU in 1997, which applied strict scrutiny to a federal internet regulation. The first time the Supreme Court took up this question of what standard of scrutiny should apply to the internet. And there are a number of other laws that were enacted in the late 1990s, early 2000s that covered the internet and raised various First Amendment issues. The reason I think it's important for us to take in that history is twofold. First, ever since effectively the dawn of the commercial internet in the 1990s, the court has been pretty consistent about arguing that the most high standard of review applies to laws that affect free speech online. And second, that the taking up of this case and the recent activity from the court on internet-related cases when it comes to speech, I think demonstrates some unease with those longstanding precedents. As we all know, this is not the Supreme Court of the 1990s or the early 2000s. So in the early 2000s, the Supreme Court took up a case twice called ACLU versus Ashcroft, which I'll collapse into its ultimate holding, which is that the age verification statute regime that was enacted in Ashcroft failed strict scrutiny, unusually not because of the lack of a compelling governmental interest. The court agreed that age verification could be a compelling governmental interest, but rather because that interest could not meet the other prongs of strict scrutiny, narrow tailoring of these restrictive means. Why is that? Because the court reasoned in Ashcroft in 2004 that technical limitations would be a better, least restrictive means of limiting minors' access to explicit content online. Basically, we don't think, the court said, that law is the way to achieve this goal. Rather, technical limitations, would be a more appropriate method because it would be less restrictive. The age verification statutes, there are multiple problems with them from a First Amendment perspective. One of them is that they tend to have massive inclusive problems, right? Are we over-inclusive, under-inclusive? Is a minor, someone who's 17, really someone we should treat similarly to someone who is 6? There are all kinds of content, if we think about obscenity, that might trigger an obscenity rule, but also might be things that minors have legitimate access to. If age verification can be easily circumvented, what are these laws even doing, et cetera, et cetera. Cut to now, we, I think, are in the midst of yet another installment in the culture wars, and there are concerns, about, children in schools. What are they reading in libraries? Are they seeing drag performers? Are they having access to explicit content online? Should they be learning about sexual health? Should they be learning about reproductive rights and abortion? And so multiple states have enacted these age verification statutes in an attempt to limit minors' access to explicit content. What's startling from a jurisprudential perspective is that the laws that these states enact are functionally, I think, equivalent from a constitutional standpoint to the law that was struck down in Ashcroft. That is to say, states are enacting laws that, if they cared about their constitutionality, they would quickly realize are not constitutional under current Supreme Court precedent. So what's the goal here? I think it's pretty similar to what we've seen in other areas of law, most notably in reproductive rights and abortion rights, which is that states enact laws that they know are unconstitutional in an attempt to try to test the boundaries of that or see if they have the votes to overturn that precedent, as anti-abortion activists were able to do in the context of Dobbs. When Mississippi enacted the law at issue in Dobbs, it knew that it was not constitutional under Roe and Casey, and yet enacted it anyway, and look where we are today. This is obviously a very different realm, but I do think that Texas's efforts here were an attempt to try to get the Supreme Court to revisit the Ashcroft decision and say, we think that strict scrutiny is satisfied, or we don't think that strict scrutiny is the right standard here. The trial court overturned the law, unsurprisingly. I think the district court realized that this wasn't going to meet the precedent. The Fifth Circuit reversed in a 2-1 decision, which I think really made a hash of the standards and did not properly contextualize the cases that were relied upon to find for the state. The Free Speech Coalition, when they sought an emergency stay of the law after the Fifth Circuit ruling, did not get it from the Supreme Court in the spring, which I think does not bode well for them in this challenge, because if they could not get the votes for a stay to enjoin this law 5 or 6 months ago, it's hard for me to see how they're going to get 5 votes to overturn the Fifth Circuit and find the law unconstitutional. For me, from a constitutional perspective, I think that's quite unfortunate, both from the fact that I think the court should not be overturning this precedent just because it has different membership, but also because the law, really, I think, unconstitutionally limits, under what we think the First Amendment is designed to protect, access to information that's protected by the Constitution. So I envision a ruling in which the Ashcroft decision is either limited or overturned, and that Texas's law will be allowed to stand. I think it's possible. Some, I think justices are not fully on board with the idea of staying state laws or federal laws when they come up on the emergency docket. And so perhaps I'm, not counting the votes properly, or thinking that maybe we're in that the Free Speech Coalition will face a tougher audience than it might. It may just be that the justices would rather prefer to wait. But I think that's a little bit unfortunate in the First Amendment context, where injunctions are a little bit more common, because even a minimal limitation on access to content protected by the First Amendment is seen as a severe harm. And so the fact that we have a world in which Texas's law was able to be in effect for much of 2024, I think even if the court overturns it next year, I think will still have been a loss for First Amendment values. So I'll stop there and look forward to questions.
Excuse me. Thank you very much, Gautam. I see, and it is much appreciated, Professor Iyer. I see that you're asking a question right now in the Q&A. Please feel free to relay the question and answer for the room, if you don't mind. You're still on mute.
Yep, got it. Mid-typing. So the question was whether or not it's likely that the court will hold the BPJ case pending the ruling in Scrimeti, and then grant vacate and remand back to the Fourth Circuit to consider in light of Scrimeti. So this is certainly possible, but it wouldn't actually resolve the issues or fully resolve the issues or grant the relief that the government wants, the state government here wants, because the Fourth Circuit found for the plaintiff there, both based on the Equal Protection Clause, they said there should be further proceedings, but more decisively based on Title IX. So again, this is an athletics case out of the Fourth Circuit, where the Fourth Circuit said, as applied to this plaintiff, this violates Title IX. and that summary judgment shouldn't have been granted on her equal protection claim, although it requires further proceedings in the district court. So Skrmetti is exclusively an equal protection case. It has no Title IX claim. So whatever the court does there won't fully resolve the issues in BPJ. It's possible they could suggest they should reassess the equal protection issue, but that wouldn't alter the actual outcome of the case because of the Title IX ruling.
Thank you. And Gautam, there's a question for you here, which is that Justice Thomas was in the majority in Ashcroft. Do you think he'll take a different view here in the Free Speech Coalition?
Yeah, that's an interesting observation, and frankly, one that I hadn't remembered. I think that Justice Thomas's views may be different as compared to the decision 20 years ago in Ashcroft. And the reason is that I think that he may have changed his views has to do with his activity both on the shadow docket and also in the Net Choice versus Moody case from last term about Florida and Texas's regulation of social media platforms. And there, I think Justice Thomas was much more cautious about overturning the laws at issue than some of the other justices on the court. And I think you've seen in the emergency docket his real concerns about sort of internet platforms and speech and how that may be the platforms may be insulated from regulation. I share those views to some degree, although I think Justice Thomas and I have very different characterizations of what the problems are when it comes to regulating the internet and what should be feasible. But it wouldn't surprise me to see him have a different take on this case than Ashcroft, because I think that we've seen that his views in other internet-related cases are not fully consistent with the ruling in Ashcroft.
Thank you. And I think what I should do here, since we are so short on time, is I'll try to start with Dan. What I left out of Dan's bio is that Dan's proposal for court reform has been endorsed by now Mayor, former presidential candidate Pete Buttigieg, and so I imagine this is something you've thought about quite a bit. So I'll start off with the kind of softball question a student might ask you after class or something, Dan. I mean, how does someone who has proposed reform like yourself and thinks it is doable and workable, how do you think through that Republicans, there are already signs that Republicans seem to be will be in lockstep against any reform?
So, I mean, I definitely am somebody who's proposed reform. I wouldn't necessarily say I'm someone who thinks reform is super likely. I think it's at the stage we're at, it's something that we need to continue having a discussion about, even though it does not seem super likely in the at least in the short term. You know, the Democrats had the trifecta briefly, and that would have been the opportunity to do some kind of court reform, but there wasn't political support to do so. There wasn't political support from the kind of pivotal votes in the Senate. There wasn't political support from President Biden. President Biden has come around on it, but at a point at which it's too late. So I think it's basically at this stage we're at, it's a conversation we should keep happening, keep thinking about what's wrong with the court. Different people are going to have different diagnoses, and this lead to different suggestions for reform. But I think that conversation is likely to continue the more that the court does things that are seen as kind of out of step with what the American people want. And I continue to have, you know, regular conversations with the staffs of people in Congress, senator staffs and things like that about different proposals they're thinking about. So I would just say, you know, let's keep talking about those kind of proposals. Let's keep thinking about them. Let's see those as realistic options to the extent that they, you know, really become seen as necessary, and to the extent there really becomes a window of time where reform is possible. I don't know when that window will be. I don't think it's going to be in the next couple of years, even if Democrats win this presidential election. I think it's unlikely there will be, you know, that there will be enough votes in the Senate to get any reform through, but that doesn't mean it's not worth continuing to think about these issues.
Thank you very much, Dan. And we are obviously fast running out of time. I think I'll allow some room if any one of the panelists has a strong urge to make some closing remarks. I'd be happy to allow that. But we are otherwise running out of time. Thank you guys again. Thank you to all the audience members for joining us. Thank you to ACS for putting us on. Thank you again to each of our panelists. Really wonderful to hear you guys talk about these subjects and lay out the coming term for the court. So thank you again, everyone.